Do you swear or affirm that you will tell the truth in this matter, the whole truth, and nothing but the truth?
I do.
Thank you. State your name for the record, please.
Matthew L.M. Fletcher.
Hello, Mr. Fletcher. My name is John Petoskey. I'm an attorney for the Brookhaven Band. So first, you were called by us today to be our qualified expert witness to testify on matters relating to Indian child welfare as well as the Brookhaven Band itself. So first, I'm just going to ask you some questions about your background and your credentials. So are you a tribal member?
I am. I'm a member of the Grand Traverse Band of Ottawa and Chippewa Indians.
Okay. And where were you educated?
I was educated at the University of Michigan right here in Ann Arbor, 2 times.
Okay, and what were those 2 times?
I got a BA in English in 1994 and a JD in 1997.
Okay, and where are you currently employed?
Michigan State University College of Law. I'm a tenured full professor, and I'm also director of the Indigenous Law and Policy Center. I'm also an appellate judge for 8 Indian tribes around the country, including 4 here in Michigan.
Okay. So what do your job duties entail with regard to those various positions?
Well, I do, as a tribal judge for Grand Traverse Band, I've actually been an appellate judge in an Indian child welfare matter that originated in state court. The Indigenous Law and Policy Center is also a clinic and has an Indian child welfare appellate defense clinic. So I participate in strategy meetings relating to Indian Child Welfare Act cases that are currently on appeal in federal and state courts around the country. I write a lot of amicus briefs on ICWA and other cases as well, but a lot of our work is the Indian Child Welfare Act. And in my previous career, before I became a law professor, I worked in-house for various Indian tribes, just kind of like how you work at Brookhaven. And then as an in-house counsel, I often advised the tribe's Indian child welfare social services departments and appeared in state courts on behalf of the tribe as well in those cases.
Okay, so are you familiar then with the structure and culture of the Potawatomi Band?
I am.
Okay.
My grandmother was born Laura Brookhaven, so I'm actually a descendant of Leopold Brookhaven himself.
Oh, cool. So are you considered an expert in your field?
Yes.
Okay, great.
I'm not sure he's the one that should answer that. All right. Is there any objection to the expertise of this particular witness? All right.
Okay.
We'll accept him as a witness, as an expert witness.
Great. All right, so now I'm going to ask you some questions about the history of Indian families and the emergence of ICWA and MICFA, as well as the history of boarding schools. And so can you tell us what the United States assimilation policy is?
Okay. In the 19th century, the United States often referred, the people, policymakers in the United States often referred to Indians as the Indian problem. And they were frequently trying to come up with solutions to the Indian problem. There was Indians around the country, many of whom didn't speak English, weren't educated in American schools or Christian schools, and did not live the same way that Americans did. And so the United States engaged in a wide variety of policy decisions that typically you could just call assimilation. The idea was to turn Indian people into Americans by making them behave like Americans do. And that meant going to school and learning English, becoming Christians, becoming farmers, or wage laborers, that sort of thing. And the big policy choices made by the United States in order to encourage that were to take Indian kids from their families where they would learn Indian religion and culture, speak Indian languages, and send them away to schools, mandatory boarding schools, some of which were operated by the United States government itself, often under sort of a rubric of like a military boot camp type of situation. And other schools were operated by Christian and Catholic churches, really missionaries. And so that's primarily the big push toward assimilation, was to start with kids. One famed line is that from Colonel Pratt, who ran Carlisle Indian School in Pennsylvania, was, we have to kill the Indian in order to save the man.
Okay, and how were children treated in these boarding schools?
There's lots of stories of abuse. It's hard to quantify how many kids thought they were abused, but the description that pretty much everybody agrees with, at least on the military boarding school side, really was like a military boot camp kind of situation. There were lots of rigid uniformity was absolutely required. Physical violence was pretty typical. Sexual abuse is also very typical. I'm sure you've read in the paper about the United States and Canada. Catholic schools and Catholic churches just generally having trouble with child sexual abuse over the last 100 years. That was an epidemic within Indian boarding schools. So it's fair to say that if you went to a boarding school, either the military federal government style or the missionary style, you were probably subjected to, if not directly, or you were surrounded by physical and sexual abuse.
Okay, and when did this boarding school era policy end?
When did it end? Oh, I think it's fair to say that it probably started to decline dramatically during the Great Depression. That's when the United States passed the statutes like the Johnson-O'Malley Act, where they would take federal money and send it to the states to fund schools to educate Indian kids. But there are still boarding schools to this day. They're not operated like they once were, but the BIA has dozens of boarding schools now even, so it never really ended.
Okay. And what was the effect on tribal communities and governments like my client, the seizure of children?
That's a pretty broad question. We could talk about that all day. Okay. So a person who went off to boarding, let me describe the story of my wife. My wife is also a law professor, and she's a member of a tribe up north, Little Traverse Bay Bands of Odawa Indians. Our son is in the back right there playing video games right now, even though he promised me that he was going to pay attention. Him and his brother are the first child in my wife's family, first generation that has not suffered some sort of removal since before the 1830s. He's 5 generations back. My wife's sister, in 1977, 1 year before the Indian Child Welfare Act, was taken while they were at church by church representatives to another city and paraded before a group of possible white families who wanted to adopt an Indian child. And somebody selected her. They had a court date the next day, at which my mother-in-law was not represented by counsel and was coerced into consenting to an adoption of her 2-year-old child. My wife at the time was 4. And so they went off to Columbus, Ohio, and my wife did not see her sister again until her sister was turned at least 21. That's when under ICWA you can open up and try to figure out the court file. So before that, my mother-in-law had a family of about, I wish I could remember, at least 6, maybe 7 or 8 siblings, all of which were removed from Emmett County and split up. So she was luckily kept with her twin sister, but all the other siblings were sent around the country. Some went to Detroit, like my mother-in-law and her sister. Some went to Phoenix, some went to San Francisco, some went to Minneapolis, all to white families with the intent of sort of draining the Indian from them. And before that, it was boarding schools. So the generation before that was sent to Holy Child boarding school. The generation before that was sent to a combination of Holy Child and Mount Pleasant Indian boarding school, which is one of those military-style boarding schools. And the generation before that was the 1830s. That's how far back it goes. And that generation was subjected to what is known as actually the removal era. It's a different kind of removal. That's where the United States government forced Indian people to move from their homelands to other locations. So my wife, Winona, traces her family to Allegan County. So they're actually Potawatomis too. Ottawas and Potawatomis were in Allegan County in the 1830s. And they were removed by the United States. And her ancestor, a guy named Antoine Shenandoah, moved from Allegan County to Leelanau County and then over to Burt Lake, which is in Emmett County, I believe. And so even that was removed, and he was separated from his parents even then. So what that means is that there are whole generations of Indian people who have never actually had a model parent. They don't know how to parent. and they've suffered these traumas, and these things get passed down, and frankly, they sort of like a boulder rolling downhill. It gets worse and worse and worse. And it's fair to say that a lot of Indian people have what I guess you could say is sort of like a post-traumatic stress disorder that happens by going through that process, and also just being and growing up around people who've gone through that. So it can be pretty difficult.
Okay. And so what are ICWA and MIFPA?
ICWA is the Indian Child Welfare Act, and MIFPA is sort of a codification and clarification of the Indian Child Welfare Act under state law, the Michigan Indian Family Preservation Act. ICWA is sort of the minimum standard that is required in order to in the event that a child, an Indian child, is in the custody of a state, is the ward of a state. And it provides some specificity and some minimum standards, but that's about it. And then MIFPA is a more recent statute just from the last few years, in which some of the more ambiguous terms, like what active efforts mean or what a qualified expert witness is defined for purposes of state law.
Okay. And so do these bills force children to live in Indian communities?
No. Especially here in Michigan, the reservations were all, many of the tribes in Michigan were subjected to something known as administrative termination in the 1860s and 70s, and that's where the United States just stopped providing services and acknowledging the sovereignty of the Ottawa and Potawatomi tribes here in Michigan. So that meant that their land bases were divvied up and never really firmly established. So very few people actually live on, relatively speaking, actually live on reservation land. They live in Indian communities perhaps, but it's sort of under the jurisdiction, had been under the jurisdiction of whatever state land would be. But no, the ICWA does not require anybody to live on the reservation, not at all.
Okay, so so how would it handle then an Indian child in an urban setting, for example, who is in the state court system?
So if an Indian child living in, say, here in Ann Arbor, which is, there's no Indian country specifically here, and a child is removed by the state, what is supposed to happen at that point is somebody has to ask the question in a courtroom just like this, or if not before, is this an Indian child? Or does anybody have a reason to believe that this is an Indian child? And I'm here to tell you, as somebody who's studied this, nationally, that's supposed to happen in every single case. It happens in probably less than 2% of cases. So if that does happen and somebody has reason to believe that this might be an Indian child, everything at that moment, no matter where the kid is located, has to stop for 10 days while the tribe is notified. And there's a formal notification process described in the Indian Child Welfare Act. So let me give you an example. If in this case somebody said maybe the dad is Potawatomi, every single federally recognized Indian tribe in the United States that is Potawatomi, and I think there's 7 or 8 of them, has to be formally notified under ICWA, as well as the Bureau of Indian Affairs, as sort of the catch-all. And the weird thing about the BIA is, the weird and creepy thing about it, is they have records on all of us, Indian people. So they're actually fairly effective for a big federal government bureaucracy as a catch-all for ICWA purposes. They can look us up pretty easily, but that's an aside. So it doesn't matter where the child is located, so long as the child is a tribal member or is eligible for tribal membership with a federally recognized tribe, then the Indian Child Welfare Act applies.
Okay. Now I'm going to ask you some questions about the Pokagon Band of Potawatomi Indians specifically.
Sure.
So what exactly is the Pokagon Band of Potawatomi Indians?
Pokagon Band of Potawatomi Indians is a sovereign government. It is a federally recognized tribe. There's 572 federally recognized tribes in the United States. The Potawatomi Band has multiple treaties with the United States. The treaties are negotiated by the executive branch and ratified by the Senate, making it essentially an Indian tribe, a federally recognized Indian tribe. Like I said, however, starting in about the 1860s or 70s, the United States stopped paying attention to them. But in 1994, Congress restored the tribe's federal recognition, we call it, or basically it's the United States government's acknowledgement of its sovereignty. But as a tribal government, it's loosely analogous, I speak that very, very loosely, analogous to a municipality. Imagine a municipality that has 3,000 or 4,000 acres of jurisdiction land, but that it's little bits of parcels, bits and pieces of it are scattered over an 11-county service area that straddles both the Michigan and Indiana border. Most of it's in Michigan, but it's a government like any municipality with a bit more oomph to it in that there's an executive, legislative, and judicial branch, and it's the executive and legislative are elected officials, so they have periodic elections, and the judiciary is selected by appointment of the political branches.
And how does one become a citizen or a member of this band?
Well, you have to be legally qualified. You have to meet the criteria, and every single Indian tribe gets to choose its own citizenship or membership criteria. And the Pokagon Band has a written constitution that it ratified itself and that is actually approved by the Bureau of Indian Affairs, the Secretary of the Interior, technically. And that provides some details on what the minimum qualifications are for somebody to be a citizen. A lot of it has to do with ancestry. So if you have an ancestor, or you are on the list, there's a 1996 base roll that the tribe established after its 1994 Act of Congress that lists people who are, at that moment, tribal members. And if you are a descendant, or if that's one of your ancestors, you're eligible for membership. I understand the father in this case is actually on that list, so he is a tribal member. And how you become a tribal member when you're not a tribal member, but you're eligible, is you go call the enrollment office and go through their process to prove that you are one of those people that is eligible and follow their rules.
Okay. And so, can you tell us how the structure of the Indian family differs from the structure of families in the majority community?
Well, what I'll say is this, is that typically American society is organized sort of like a nuclear family relationship with mother, father, and children. Extended family members have limited or no real legal role in a nuclear family. So grandparents and grandmas, aunts and uncles, cousins, even in some cases, brothers and sisters, etc., are not really part of that nuclear family. Traditionally, and the Indian Child Welfare Act acknowledges this, traditionally with Anishinaabe families like Pokagon, Potawatomi families, the whole community was a family. So take her or leave her, Hillary Clinton's It Takes a Village has a lot of, is a good analogy for a lot of Indian families and Indian communities. So let me give you an example. My mother, for example, her mother was born Laura Pokagon, and with her name was Laura Mamagona when she was an adult. My mother would say that Laura and her sisters, especially people like Mary Church and Phoebe Hall, were basically the same as her own mother. And so she had a brother, she only had one brother, but she had maybe 15 or 20 first cousins that she, even to this day, considers essentially her siblings. And I've seen it, they're all old now, but they all act like a bunch of old married couples, and they really are very closely related. And so it would be totally acceptable for Laura, if she had wanted to do this, to say, she called my mother, whose name is Junior, you're going to go live with Aunt Mary this summer, and just that's what she would do. You know, you could see a situation under state law where, you know, a child is living with her aunt as being abandonment, right? Under state law, that's what it would be. In a tribal community, that would be ridiculous.
Okay. Next, I'm going to talk to you about some of the services that the tribe provides to its members.
Sure.
Can I approach to...
Certainly.
Okay. So there are 4 exhibits here, and they're just marked 1, 2, 3, 4 with staples. And
Okay.
I've given these to opposing and counsel all around. Okay, so the paper marked as a Tribes Exhibit 1. Can you tell us what this is, Mr. Fletcher?
This is a list of services, a description of services that the Pokagon Band Potawatomi provides to its members and to other people who are eligible. For example, there's something here about behavioral health where somebody can get some services in that way. The tribe has clinics where you can go and get your your dental checkup, your regular wellness visits. You can get your prescriptions filled. The tribe has land on which it builds these buildings and makes them, and has various clinics for healthcare, essentially, generally speaking.
Okay, and then all members are eligible for this, and people who are eligible for membership presumably would be also.
Yes, tribal members are absolutely eligible for these services. And it's true at Pokagon, like most tribes. To be frank, Pokagon is one of the tribes in the U.S. that is privileged with being fairly resource rich. So every tribe has the obligation to provide services to its own members, services like these health services. But it may also extend those services out to other tribal members, other people as well, including non-member Indians, and also family members who are part of a family that where there's a tribal member. So, for example, weirdly enough, my father, who is a non-Indian guy, was able to go to the dentist at another Potawatomi tribe's dental clinic for a very small fee. So.
Cool. The Pokagon Band moves to enter Exhibit 1 into evidence.
Any objection? Is that a no? Can you stand up and say no?
No objection, Your Honor.
Okay, thank you.
Okay. And so if you turn to Exhibit 2, can you tell us what this is?
This looks like a description of the tribe's social services. So tribal members who are, or people who are eligible for whatever kind of other services that the tribe provides that would be under the rubric of social services is described here as well. And also there is the word of the week, which is the word for monkeys, and I can't pronounce that one, so I'm not going to try.
Okay, and so with social services, would this encompass family services?
Yeah, I mean, pretty much anything, I mean, just like under the state system. So in the event that there is a family that is in need of care or a child in need of care, it's likely that the tribe's social services department would be activated and would provide those services.
Okay, and the same eligibility criteria applies to health and social
Absolutely,
services.
yes.
The tribe moves to enter Exhibit 2 into evidence.
Any objection?
Objection.
Thank you.
Okay, now if you turn to Exhibit 3, can you tell us what this is, Mr. Fletcher?
This is a description of the tribe's education and vocational assistance services. Includes a list of scholarship assistance and other kinds of monetary and also counseling assistance that the tribe provides to eligible people for education purposes.
Okay. Great. And the same eligibility criteria?
Yeah, I would think so, yes. I mean, the Pokagon Band has something called the Pokagon Promise, where if you're a tribal member and you go to college, they'll basically make sure that you can do that. They'll pay for it to the extent that you have any need. I don't know if that extends out to non-tribal members. I kind of doubt that, but I'm not sure.
Okay. The tribe moves to enter Exhibit 3 into evidence.
No objection.
Thank you.
All right, now if you'll turn to Exhibit 4, can you tell us what this is?
This is same thing, except in relation to language and culture. The tribe has classes in which you can participate and learn the Potawatomi language and culture. Probably involves learning about ceremonies and things like lodges and sweat lodges and different kinds of activities you can do to learn about the culture, different classes you can take.
Okay, and how do you think being involved in culture impacts a child's life?
Well, it provides a sense of belonging and a sense of who somebody is. And one of the great things that I like about our culture, our Anishinaabe culture, is that it's rooted in togetherness, and how when somebody does something that impacts others, it creates sort of other impacts on everybody. And the fact that you can do something bad to one person isn't going to just be limited to that person. It actually bounces back onto you. It affects others around you. And the same is true if we're doing something good towards somebody. So it's sort of this, what the old Indians call Manoba Mazawin, and it gives people a sense of community, and it gives people a sense of belonging and self-dignity and resiliency, so to speak.
Great, thank you. The tribe moves to enter Exhibit 4 into evidence.
No objection.
Thank you.
Okay, now I want to turn to the facts of this case and some questions about William Murray and Ricky Pena specifically. So do you know who William Murray is?
Yes, I do.
Who is he?
He's a Potawatomi band member. He's the father of a child whose name escapes me. Something Pena. Ricky Pena, thank you.
And so is William Murray eligible to receive these services that you just described?
Yes, he is. He's a tribal member, and he is eligible. He shows up and makes a phone call, makes an appointment. He can receive all of this stuff.
And that his biological child, Ricky Pena, would be eligible as well?
Yes, he's a descendant of William Pena, and if he's not already a member, he's absolutely eligible to be a member and eligible for all these services.
Okay, and then would Ricky Pena's, or I guess Ricky Pena's sister, who is not a biological child of William Murray,
Okay.
how would the eligibility apply to her?
It's likely that as part of being a part of an Indian family, so the sister, that though is not an Indian, is still part of an Indian family, is eligible, is an Indian child essentially under the Indian Child Welfare Act and under Michigan, maybe not so much MIFPA. But what that means within the tribe is that the tribe acknowledges that there may be a broader family that exists and the close linkages to people who are within their family. So siblings, maybe one is Indian, one is not, are still closely linked, and services should be provided to both of them. They are together as some sort of unit, along with whatever parents are available, along with, and extend that out to grandparents and aunts and uncles and cousins as far as you can as well. It's all a sort of a broad tapestry, so to speak. But it's important to acknowledge that tribes do treat the non-Indian siblings of tribal members as essentially as tribal members eligible for almost every service. Maybe not that Pokagon promise thing, because that can get pretty pricey in the end. But other than that, they all are, absolutely.
Do the legal standards attach to siblings who are not Indian?
Some do. So for example, if an Indian parent, or excuse me, there's an Indian child and a non-Indian sibling with a non-Indian parent, the tribe will actually, they're eligible to live on the reservation on trust land and public housing, and eligible to go to the health clinic, and eligible for all the services really that are described here. So that's the legal hook. The tribe, under ICWA, a non-Indian child and the Indian sibling are part of the Indian family, so there's legal obligations to make sure that they're not separated, to keep them together as much as they possibly can.
Okay, and what is the tribe's definition of active efforts?
The tribe's definition? Just broadly speaking, the definition of active efforts is usually described in contradistinction to what state law provides. So let me give you an example in the case of children who are taken by the state for negligence, where the parent has substance abuse issues. Reasonable efforts or passive efforts or other kinds of efforts that are not active efforts might include on the ground something akin to bringing the parent in, handing them a brochure, and saying, I want you to go to this AA meeting or NA meeting, and I will be checking to see if you've gone by calling the place or looking at the list of attendees, and I expect you to do what I say. Active efforts under state law would mean something more like the social worker physically takes the parent to the meeting and actually waits for them to go. This is a big deal for Indian people who may be sort of at a nadir of their life, where they've just lost their jobs and they're sliding into dependency, and they don't have a car. Maybe they've lost their car. And a passive efforts or a reasonable efforts kind of jurisdiction would say, well, that's just too bad for you. You're never going to see your kid again. And that's the kind of thing that the active efforts is trying to defeat. And I assure you, closer where the tribe is actually able to provide services, they would do those sort of things. And they would do so in a way that's culturally appropriate too.
Okay. And so how do the placement of Indian children, the placement preferences in foster care, can you describe what those are?
Under the Indian Child Welfare Act?
Yes.
I don't know the exact order, but it typically is the child's family, and that might extend out to all sorts of different kinds of relations.
Does that extended family have to be Indian?
No, but the preference is if there's it's sort of a tie. I mean, the tie goes to Indian. So then after that, there's other tribal member families, and then there's other Indian families, and then after that, it's more just whoever you can find on the list. But the goal of ICWA and NIFTA and of tribal law, if we were in tribal law, which we're not, would be to keep the kid as close to possible in the least disruptive environment from being removed from their actual home. So that would mean the closest family members possible, both in terms of relation and geography, and as well as just their people that they know. And that isn't always the case of what happens in state court.
Okay. And so, this is my final question for real. As a person who grew up in a tribal community, how would your childhood have been different if you were taken from your community?
Wow, that's a big question.
That's an interesting question.
It is, and it would be dramatically different. I don't know that I wouldn't have gone to college or law school, pretty sure. Let me give you an example, and I'm not trying to denigrate my father's side of the family. My father was a non-Indian guy, and he grew up in an environment where it was very religiously oppressive. There was a lot of physical abuse. And he was told over and over again when he was growing up, we're poor people, and poor people don't go to college. You can expect to do manual labor for the rest of your life. And if you don't want to, don't even bother learning how to read. And I grew up in Allegan County, and there's a fair number of Indian people there, and there's an Indian tribe there as well that's related in some ways to Pokagon, called the Gun Lake tribe. So I grew up around my mother's relatives and around other people that we knew who were Anishinaabe as well. But I also grew up in a fairly poor non-Indian community, and that kind of community is probably what I would have grown up in without an Indian family. And it was just like my dad's family. It was a bunch of people that I knew who were told that they were never going to amount to anything, they were never going to go to college, and learning math and science and learning how to read was just a waste of time because you're going to be a manual laborer and you're not going to need to do any of that stuff. And one of the amazing things about being part of a tribal community in my Indian family is that it was the exact opposite. It was always assumed that we were going to go to college, that back in the 70s, the Michigan legislature enacted something called the Michigan Indian Tuition Waiver, which made it so that if you were an Indian person, a member of an Indian tribe from Michigan, you could go to public university, and then the state would actually reimburse the university for your tuition. That's how I got to go to Michigan. Back then, Michigan tuition was, $4,000 or $5,000 a year. I probably could have figured that out. I don't know if it would not be the case now. I suspect. I don't know, but I don't know. I don't think I would have gone to Michigan. So that's a big part of it for me.
Okay, thank you very much, Mr. Fletcher. That's all I have.
Who's going next? Anybody?
Maybe brief cross. Hey, Professor Fletcher.
Hello.
Hey, I just wanted to talk about the formal notice requirement you mentioned earlier.
Yeah.
If it's discovered that there is an Indian child in a proceeding after the initial contact,
Right.
is that formal notice still required?
What do you mean after the initial contact?
So suppose the proceeding has been going on, we arrive at a termination proceeding, or it's a few months before.
Okay.
And at that point, the biological mother reveals that there's a different father.
Oh, so you mean like further on down the road?
Exactly.
Yes. Yes, unfortunately it is. The law specifically states as soon as that there was reason to know that this might be an Indian child, that everything is supposed to stop, at least for 10 days until the tribe is notified. And the notification process isn't instantaneous, unfortunately, so it might take longer than that. And that does, to be frank, does create difficulties, to say the least, at times.
Sure. Thank you.
Mm-hmm.
Anyone else?
I have no questions, Your Honor.
I have no questions, Your Honor.
Cross-examination? Good luck. luck with that.
Just to follow up on his last question, what sorts of issues can the notice provisions provide in that sort of scenario he described?
Well, I mean, you were going to end up wasting a lot of people's time. So what happens, let me give you an example of how this might work, how it usually works. And again, I'm not saying this to denigrate any court or any people who are involved in all this. I know these people are doing as best as they can. But sometimes in a late stage of the proceedings, it becomes apparent. And we've seen this where sometimes families who realize, parents who realize their rights are about to be terminated, get kind of desperate. We see this a lot in California where everybody suddenly becomes Cherokee the day of the termination hearing. And the court likely is going to think of that as a bad faith assertion of the right under the Indian Child Welfare Act. They just keep going. And what happens in California, it's the same as what happens here in Michigan, is they'll probably just keep going and you'll get some sort of permanency placement. You may even get an adoption. You may get some sort of permanent foster care situation, whatever it might be. But then there's going to be an appeal. And then when there's an appeal, nothing's really permanent. And here in Michigan, what happens is you've gone through this whole process. You've conducted hearings and fact findings and made conclusions of law based under state law. You've gotten all the way to the end, and then all of a sudden the Michigan Supreme Court says you never complied properly with the notice requirement. They'll conditionally, I can't remember if they say they reverse or affirm, whatever it is, it's the same thing. They send it back to the trial court level to confirm that it had complied with the notice requirement. And if this is an Indian child, they have to confirm that everything they have done is actually compliant with the Indian Child Welfare Act all the way through, and that includes burdens of proof. Termination of parental rights under ICWA requires the state show beyond a reasonable doubt that the parent is an unfit parent, and that's a different standard under state law. So you could have an adoption. You could have children living in a home with adoptive parents or long-term permanent foster parents, and they've been bonding potentially for years with that family. All of it could potentially be void under the Indian Child Welfare Act or federal law. And we hate to see that situation. That's why there's an obligation at the opening moments in every single child welfare matter for somebody to at least ask that question.
Under ICWA or MIFPA, is there an affirmative obligation to ask beyond that initial intake, like say 6 months down the road, if you're still going through and you've received no other information to the contrary? Is there a repeated obligation to inquire about the child's heritage?
Yes and no. I mean, if you were serious about maintaining a good process, I think there is. As a practical matter, there absolutely is an obligation to continue to ask that question because more information might come out. People might be, who don't know anything about their background, might go through this whole thing. A parent, for example, might have gone through a whole year of trying to get children back, and then we've reached a termination proceeding. Only then, perhaps, do they do an investigation. As an appellate judge, I had a case that was exactly like that, where a woman who grew up right next to an Indian reservation in Vishabitown, Michigan, who was adopted out of that tribe, didn't know that she was eligible for membership until after all of this started to happen, and people started coming out of the woodwork saying, well, you know you're Indian, right? And it was years later before she figured that out. So there are times where, as a practical matter, absolutely, there's an obligation. As a legal matter, the obligation, I think, is so long as no other evidence ever comes out again, is probably satisfied by that first question. So long as everybody knows the answer is no at that point.
Thank you for clearing that up for me. So you said you're an ICWA scholar. Are you familiar with the Supreme Court case, adoptive couple versus baby girl?
Very much so.
Decided in 2015. Would you mind giving everybody just a brief overview of what the case is?
I can't give a brief overview of that case. I could give a very lengthy and detailed one, but not a brief one.
I would, objection. I mean, this calls for a legal conclusion, and this specific case applies to this case in such a way that it should be briefed, and the court can make a proper decision upon those briefs rather than upon the testimony of the expert witness on the cross.
And I have a little bit different reaction to the question than you do, but I think your objection is a valid one. to ask, first of all, this is cross-examination, so if you want to give him the opportunity to give a dissertation, be careful what you wish for.
Right.
On the other hand, tell me what the relevance of his interpretation of a case that I conceivably can read.
There's a holding in that case that we believe would be applicable to this.
Why don't you ask him about, why don't you narrow the scope of your question to the specific holding? Professor, if you can answer it without telling us how the clock works, let's do that. Okay,
Could
so
you,
the question is,
Could you explain what the holding was regarding the active efforts required where the Indian child had never been in the Indian father's legal or physical custody at any time?
The active efforts requirement was excused.
Excuse, so there were no active efforts required for that circumstance?
That's right.
Where the child was not at any point in the physical or legal guardianship of the father?
Yes, I believe that's the case.
All right, no further questions here.
I just have one redirect. In that case, the father signed a form relinquishing his parental rights, is that correct?
Yes. My understanding was that, I don't know, it's been a while. My understanding was that it was done by text message, actually. And that ICWA requires the relinquishment of parental rights be done in front of a judge, which is not, it's a different standard than under most state laws. And the U.S. Supreme Court excused that as well and said that text messages, they didn't say a text message is just fine, they just didn't trip up the decision on that question.
But he knew he had a kid in that case.
Yes, the mother in that case contacted him in advance of the birth. They had broken up by then, they had broken up by text message, so.
Okay, thank you.
Yeah.
in the world. Anybody else? Last chance, going once, twice. I have a couple questions for you,
Sure.
Professor, if you don't mind. First of all, on behalf of Americans past and present, I think we all owe you an apology for the way that your tribes and other tribes were treated. So, second, you said something that I actually wrote down. You said something about due to the history of the way Indian children were treated, and perhaps Indian parents, as a result, were treated, that you said something to the effect that they don't know how to parent. Obviously, in this case, we have a gentleman who's not met his son yet, and but professes great desire to parent him and to parent him well. How do you resolve that conflict?
Well, it's really about about the community. So, you know, somebody who's never had a child before, I mean, I've never had a child before, so when I had a child, I relied upon my mother and my father and my mother-in-law and father-in-law and my brother and other relatives that I had. Collectively, we would put it together. Now, to be fair, I mean, that generation on my side of the family hadn't been removed. So my mother had always had a mother with her. So really the answer is that the closer you are to the tribal community and to your relatives is an ideal situation. So if you have a community, and it doesn't have to be Potawatomi community. I mean, my membership is with Grand Traverse Band. A large swath of my relatives from Antrim County moved downstate. We did, a lot of them were separated from those guys up there in Illinois County and Antrim County. So a lot of us are down here. And the weird thing about Indian people, especially Anishinaabe people, is that we move around, rotate all over the place. So my summers were mostly with my grandmother. And we would go to Walpole Island. She had relatives there. Relatives that dated back to the 1830s. They weren't that old, but the descendancy was. We'd go to Northport, we'd go up to Sault Ste. Marie, we'd go to Western UP. And these were people all over that were all related, and they had a connection. And so I realize that when I say that people don't know how to parent properly, and they've often not had model parents, that's not exclusive to everybody in your community. Right. Some people were able to avoid boarding school. My grandmother actually was able to avoid boarding school at Mount Pleasant because when she got there, they turned her away. She tested positive for tuberculosis, so they put her in quarantine for a while until my grandfather broke her out, and so that's a different story.
And Relative to the facts of this case, do you know anything about Mr. Murray's family in terms of who's still alive, who's in the area, those sorts of things?
I don't know specifically about Mr. Murray, but I'll say two things. The first is coming back to your community after being adopted out, or after going to boarding school, or being sent away through the BIA Urban Relocation Program, or even just going away to college. The great thing about any country is that they want you to come back. And that's why there's a tribe, to bring people back. And if you talk to the tribal leaders there, like any other tribe in Michigan, that's really why they exist, is to try to bring as many people back into part of the community. The other thing is, I think that's even inherent with the way the Indian Child Welfare Act is described, because the statistics will show you when it comes to Indian parents that have had their kids removed, it's not because of abuse, it's almost always a neglect situation, a dirty home situation. So those are the best possible ways to rehabilitate. And one of the things about tribes as opposed to states, states get funding under Title 4E for a year. And that's the only reason they start termination proceedings after a year, is because that's when the funding runs out. And tribes, especially a tribe like Pokagon, can afford to keep working on rehabilitating a family, to reunite a family for years and years. Tribes are in it for the long haul. They're playing the long game.
Now, on Exhibit 1, I believe it is, you were given a list of, or I should say, Exhibit 1 is a list of services that would be available to Mr. Murray and conceivably also to Ricky under certain circumstances.
Yes.
And I'm sorry I haven't had a chance to study this in detail yet, but does this, if you know, also include substance abuse treatment?
Oh, absolutely. And I wish I had more time to talk about substance abuse treatment, as opposed when council asked about active efforts. A lot of tribal members have a hard time at Alcoholics Anonymous and Narcotics Anonymous. They often meet in churches, and if you've been to a boarding school at Harbor Springs, you might not think so highly of churches or Christian or Catholic religion. So tribes will have their substance abuse, the options include more traditional non-church related services.
Right. And I won't say last question, but close to last question.
You're the judge, you can ask as many
Yeah,
questions as
no, I was chiding them for saying last question and then asking four. So. I was a little confused perhaps about whether, for example, and let's drill it down to this case, Ms. Pena, would she, as the mother of Ricky, the Indian child, would she be eligible for any services that are denoted in Exhibit 1?
That's a good question, and it's really tribe specific.
Okay.
And I suspect that if the tribe has resources, that they would be interested in having her be a part of it.
We don't know for sure right now.
I don't know, not off the top of my head,
Yeah.
but my sense is that the answer would be yes, that she would be eligible. Especially since, sounds like more so than the father, she's actually had his visitation with them and over the years, so I think they would want to have her involved in.
Thank you very much. Anybody have any other questions based on that testimony? Thank you.
Thanks.
You're excused.